He will moderate from the University of Luxembourg, and our first speaker will be Abhilash Nair from the University of Strathclyde. His principal area of research is internet law, with specific reference to censorship, children's rights, and internet pornography. And he's currently publishing a book, Regulation of Internet Pornography Issues and Challenges, which is forthcoming in this project. Our second speakers are Aurelien and Pierre from a media advertising firm that monetizes adult website traffic, and we will have a technical presentation on this issue. And our third speaker will be Hörnle from Mary University. She's a professor of internet law, I think you know her, and she's teaching internet and e-commerce, and also was the chair of the independent, on the board of the ATVOD, the independent co-regulator for television on demand. And our fourth speaker is Siry from the University of Luxembourg. He's currently publishing his PhD on this topic, and is publishing this as a book, and the title is Knowing It, When It Is Seen, the Polemic of the Regulation of Sexualized Speech in the United States and Europe, and he will wrap up with the session.
I just briefly, for 10 minutes to talk and for 16 slides to go through, so I'll go through some of the slides. If you look at the regulation of pornography before the internet, if you look at the rationale of regulation of pornography, you can see a few different perspectives. One based on morality, which is reflected in the UK, obviously, Protections Act 1959, for example, feminist perspectives on that. But the internet sort of made things slightly different. For a start, it became a lot easier to access content from the privacy of your home. Right? It became a lot easier to publish, to distribute pornography. And also a newer form of porn, not calling it entirely novel, but newer form of pornography, virtual or pseudo pornography, started becoming popular, or becoming increasingly popular in the internet age. So, the traditional regulation largely focused on the publisher or distributor of content. Initially, there were attempts to apply that model to the internet, but there were a number of problems stemming from jurisdictional issues, as you know from the case, and also there were fairly different divergent views on what constitutes unacceptable content, what constitutes obscenity across different jurisdictions. It was very difficult to apply a uniform standard on the internet, which was a major problem. But obviously led to a number of debates regarding the suitability of traditional regulation for the internet, which resulted in a number of calls for reform. In the UK, for example, there was a Home Affairs Committee in 1983 which looked at the practicalities of existing legislation to now, just to give an example from a UK perspective, a number of new legislation amendments to existing legislation were introduced from 1988 onwards. And they started introducing what is known as possession offence for content by imposing liability on the end user. So it was no longer just an offence to publish or distribute content, a certain type of pornography called for an actual possession offence. Even a simple possession of certain kinds of pornography became indeed a criminal. Starting with child abuse images in 1988, was the first one of the Justice Act, made it a criminal offence to be in possession of child abuse images. The 1994 Act extended that to pseudo images, which does not actually involve actual children, but typically a digitally enhanced image blending the face of a child with the new body of an adult to become more from a child. In 2009, we saw that going further to virtual child abuse images of cartoon, which does not feature any real child, be it pseudo or otherwise. That was fine, sort of, until 2008, when there was a new legislation introduced, which criminalised the possession of what is called as extreme pornography. We're looking at no child abuse. We're not looking at child abuse images here. We're looking at adult pornography. 2009 2008 Act made it a criminal offence to be in possession of what is called adult extreme pornography. That's what I want to talk about a little bit here, just to give an example of how the focus of regulation has shifted away from traditional publishing and distribution of content to the end user imposing end user liability. Now, what was the logic, what's the rationale behind possession offences? First thing is, it will address the demand and supply issue. So if you deter people from possessing that kind of images, then obviously that will have an impact on the demand, hence you can call it supply. It will address jurisdictional issues. You don't have to worry about a chap who lives abroad. You can go after the chap who possesses that image within your jurisdiction. And also, in order to criminalise content, or possession of content, you have to justify it in some ways. So, prevention of harm, but I'll talk about the harm rationale in a bit more. The difficulty, though, between child abuse image on one hand and adult extreme pornography on the other is that there's a huge difference. Children cannot consent. So the inability of children to consent to for new photograph makes child abuse images or the regulation of child abuse images inherently different to adult extreme pornography, which often feature consenting adults. Just to sort of give a snapshot of what the adult extreme pornography possession offence in the UK looks like, an image falls within the law if it portrays in an explicit and realistic way any of the following: an act which threatens a person's life, an act which results or is likely to result in serious injury to a person's head or genitals, an act which involves sexual interference with a human corpse, or a person performing an act of intercourse, or sex with an animal, dead or alive. And a reasonable person looking at the image would think that any such person, animal, was real. Now, the criticism, the early criticism of that legislation was that it would cover not just actual harm caused to participants, but also cover realistic depictions, which would easily cover a clearly crafted image, a clearly crafted video, well directed stage production, consenting, where no actual harm was caused, just the overall impression that harm was caused. There was a lack of definition initially for what constitutes a serious injury. Right? I'll just sort of gloss over the rationale. There was a consultation document launched prior to the enactment of the legislation, and the Home Office said that it will clear the new legislation will send a clear message about this kind of material, it will make it easier to produce and not for it. Questions that can be asked in relation to that statement is how much of this originate are hosted in the UK? Very little. Is there any evidence that there is a significant consumer base in the UK for that kind of content? Again, very little. But that's not really relevant to our discussion today. The point I would now need to think about from a privacy point of view or a human rights point of view is that what restricting access to adult pornography, extreme or otherwise, would constitute a restriction of speech. What about privacy, freedom of thought and conscience? Does it amount to controlling private thoughts of individuals? So the state actually telling you, you cannot be looking at that kind of content, we cannot provide you any evidence that looking at that kind of images will harm you or anybody else, but we don't want you to look at it, which I think is good. Right? So does that extend legislation, the sphere of regulation, to controlling people's individual thoughts? Is it imposing a duty on people to have good thoughts at all times, rather than looking at horrible images? Right? Is it justified because it's a practical option? You can go off and endorse it if you can't find a guy in California, for example. Right? And finally, do people understand the law? We are a few years on since the law came into force, and we've had a few rather unfortunate prosecutions, which is rather embarrassing. So, do people understand the law or its rationale? It's a big question. I talked about criminalising content, possession of content. You have to justify it some way. Right? And harm, addressing harm, could offer suitable or sufficient justification if you can prove it. Harm can be divided in context. I'll quickly talk about harm, direct harm and indirect harm caused. Direct harm is what's caused to the participants, and indirect harm is what's caused to society by people who watch that kind of content. But that you're not looking at the actual harm caused to the actors in the video. The problem with the consensual harm, the direct harm argument, is that a vast majority of the material are actually created by consenting adults. Right? And also, it's not illegal in the UK to actually perform some of the activities covered by the legislation in real, right? Provided that harm caused during production was within legally permissible limits as enshrined in R and Brown, which means that it leads to a situation where the Act effectively criminalises possessing and recorded image of what might be perfectly legal acts. So it's okay to do it, but if you record it with somebody else who's in possession of that content, then it's a problem. And it's even more worrying because it's not difficult to give an overall impression that harm was caused because of advances in technology. Now, just for argument's sake, you actually think about a situation where the material was produced whereby actual harm, illegal harm not permitted by law was actually caused to participants. Again, it was the possession of things. Address this in terms of punishing those involved in production? Answer was no, because it only targets the end user or individual who would have nothing to do with the original production. Indirect harm, quickly, again, it's the harm caused to wider society. Lack of evidence is a big problem. There is no conclusive evidence. I'm not denying that there aren't any studies at all which point to harm, but you find an equal, if not more, number of studies which point otherwise. And if you, again, think about indirect harm from pornography, internet pornography, what about video games portraying violence? What about, do you watch Quentin Tarantino's films? Very child-friendly, aren't they? Why would that be permissible and not internet pornography? Is it because of the degree of perception of fiction attributed to other forms of media compared to internet content? I don't know. So, in absence of conclusive evidence of harm as a possession offence and causing liability to end users, justified the conclusion that I draw from a harm perspective is that a possession offence for adult pornography addresses neither direct or indirect harm. Now, what does that lead to? What are the implications of that? As I said, people, if you can't prove harm, where is the rationale in asking people not to look at certain types of content? Maybe in bad taste. The majority of people will find it in bad taste. I'm not arguing for the promotion of extreme pornography in any way, but what I'm saying is if you cannot offer sufficient justification for restricting access to basis of credible evidence of harm or any other disadvantages, it would have serious implications on rights to privacy. Article 8 of the ECHR, directly in conflict. Do we have a duty to have good force at all times? I don't know. So, what's the purpose function of the law? Difficult to decipher. Do people understand the law's rationale? There was a case involving a tiger porn case which came to trial, and on day one the prosecution realised that it was actually a joke, but a man wearing a tiger suit rather than an actual tiger having sex. But it took a lot of time, a few months, an actual start of trial for them to realise that. Just to summarise, Trust Reed in this book, Making Laws Inside Its Base, has beautifully put in. Law does lose its legitimacy when it doesn't command respect and compliance people. Content of the law must demand the respect of the cyberspace user if it is to have normative effect and thus influence the user's behaviour. Law must appear to be aiming at some sense of them to have any prospect of succeeding, or when it's difficult to enforce. And in my view, extreme pornography, adult pornography, offence in the UK is spectacular in its both aspects of wording. And just a final point, what I'm trying to say is it's perhaps because of the all practical difficulties in terms of applying traditional regulatory models that prompted states to start thinking about newer forms of regulation. And while it does work to a great degree for Chinese images, there's an increasingly worrying trend that the focus of regulation is moving away from producer distributed content to end user, increasing greater degree of liability. I can see a few faces disagreeing. I'm very happy to take questions. Thank you.
I think in view of the time frame, we'll stick to collecting questions at the end. Otherwise, we will already now get into full discussion and move on to our next speaker. Okay. That will need a technical. Due to us being in a wireless slam dead place here, which indeed challenges technology even more. Maybe what we do to skip then is we will actually allow one question, okay?
You said you didn't want to talk about child abuse images, but I was struck by the equivalence in the issue that they've changed the law to say that 18 is the age of consent for making images, and 16 is the age of consent to actually engaging in sex. And so we have the same parallel there, that it's legal to have sex at 16 or 17, but it's illegal to take a nude picture or pictures of you having sex at 17 or 18, at 16 or 17. So I think there's some parallels there within the child abuse imagery, that we've got some of the same issues that are coming up.
Yes, I think, well, I know it's not ideal, because you can't look at 18 as a golden age when everybody becomes mature and then grown up enough to make difficult decisions. You might find a 16-year-old who has a mental maturity of a 25-year-old or a 38-year-old who thinks like a 16-year-old sometimes still. But I can see the rationale, because the permanence actually related to images rather than sex. It's a private act, and now it's creating an image which has more of a permanent nature compared to. I do appreciate your.
And we will do.
Just going to suggest
We will do without
that's the problem with cloud. If you don't have things local, right? But I think you do just go ahead.
Hello everybody. So we will do without a presentation. It's the beauty of technology. So I'm in charge of operation for a big advertising company, and some of our products are into the internet pornography. Aurelien is the head of advertising for all Europe, so he will explain to you a bit about the advertising principles on advertising, and especially in porn. So the goal of this presentation is to present to you and to help you to understand why data is money on the web, and especially in porn advertising. The goal is not to collect personal data, it's about browsing that data. So you will have the chance to understand what's going on.
So basically, when you are on a website, you are simply, there's only one actor, the website itself, and in fact there are several actors. The first one are traffic creators, what we call traffic creators. It's the type of actors that is producing content or giving content to people. And typically in the adult industry, we've got something which is called tubes like YouTube, the same way exactly, but for adult content and especially pornography. So their main goal is to create traffic, to attract people to their sites. Then you have people for bringing this traffic. I mean, some people need to buy this traffic to get this traffic to another type of site, which are paying websites. So typically, the advertising on the system between advertising and this site is this one. You've got the original site with the traffic, and you've got people that want this traffic and that want to monetize this traffic. So, of course, everyone in this system is merchant, and everyone has something to buy or something to sell. And the main goal of everyone is to making money.
So, before 2008, advertising in porn, and mainly internet advertising, it was mainly you put a sign somewhere and you hope that this will work. After 2008, the ability to collect a lot of data about browsing history of the user, or to collect a lot of information about the system is using, the geolocalization of the user, the internet service provider of the user, the screen resolution of the user. This helped a lot the tubes to come in and to start a bit in the business. So what they did was not really legal. They looked over the web and they tried to find a lot of premium content that it was paying. You had to pay for watching this content, and they hacked it. They put it somewhere on the tubes, and after they caught a lot of traffic, a huge amount of traffic, because everybody was able to view premium content for free on the tubes. So it's like YouPorn, Pornhub, RedTube, Extreme Tube. To date, there is a lot of them, and with that premium content available for free, they contacted the premium content creators, editors, and they offered them to put advertisement on the tubes to make money with that. And the goal was to promote premium content on free premium content. And so after that, after 2008, the tubes became the first entry point of anyone who wants to watch porn on the web. So tubes are really the main market. This is because the user, when he's on the web, what does the user want is free content and a huge amount of content, and immediately. When the user is browsing for a long time, usually it's because he's looking for really something special or something really premium. And for that, he's willing to pay, and this is where advertisement is coming in, on the tubes. So the tubes business model is to offer a lot of free content, to build the most and complete accurate profile to be able to advertise at the right place and at the right moment the advertisement for a specific content and paid content. So, as you understand, tubes like YouTube for the mainstream content and porn tubes are becoming really the big data on the web. This is where you can find the big data because they are tracking everything on your browsing. They are tracking everything about the thematic, specific content you are browsing, the categories you view, the time you spent on every video, the tags are related on every video, the visit frequency you are doing on a lot of different videos, your localization, your language, your city, the time you spent on the preview, you're willing to pay on any content. So with that, all that tracking allows them to put a good ad space, a good advertisement at the right moment for the right user.
So what does it mean when you are advertising? As Pierre said, in the past we were website centric. We thought that if you were on an adult website, you were likely to love every adult content that we can give to you. Nowadays we are data centric. That means that if you get data, if you, for example, if you are looking at a specific content, you are making specific research on the website, you have to see an advertisement which is related to this specific research. And today, mainly tomorrow at least, we'll have a profile-centric point of view. That means that you will be a profile when you are watching something. And if you are in this profile, you are likely to love this type of content and will provide this type of content. What does it mean? That we don't need to have your ID. We need to have what you want as a content. I mean, specifically, it's something really important to understand. We don't care about who is on the website. We care about what the person which is on the website wants. That's really different. We don't want to have special information about his ID, we just want to see what we can give to him and if this content will be interesting or not for him. So that leads to the most advanced part of advertising, which is real-time bidding. I mean, if you get profiles, you get something which gets a value, and everyone wants a specific profile. It's really different from the past advertising. In the past, you were, as Pierre said, you are putting sites somewhere and hope that someone will like this sign. Now you are putting a sign for someone at a place, at a time, and at a profile. So that's really a different system, and that's really related to data. The more data is accurate, the more we can target people, and the more we can have better results and better advertising. You won't have, if you just go out porn for a second, you all have an activity on the internet, and you will see your data used. For example, when you are watching for a camera, in the following days you will get advertising for cameras. That's exactly the same thing that is happening in the porn industry right now. If you are looking at specific types of person, of anything, you will see advertising which is related to these specific types.
So you now understand that the more data is collected from the tubes, the more they will be able to send advertisement on a better targeted ad space. So the most accurate is the targeting on the ad space. The more sales they will get from the advertiser, so the more they can sell advertisement, so the more money they can make. So the data that you are providing anonymously when you are browsing on YouTube is money for advertiser and is money for the tubes.
Thank you very much for that. And especially for taking over the technical problem. Okay. The presentation, I think, raises several questions also in terms of economization, but again, I would suggest we reserve them and first continue the presentation. So, Julia, it's up to you.
Okay. I'm not. The first point I'm making is very important. It's not a moral point. It might sound like one, but that's not. I'm talking about facts, not morals. But I think. I mean, I'm really tempted that I won't to ask the audience who's been on the porn sites, on the tube sites. I was appointed director of AdWords in 2010, and the first thing, obviously, when I started the job was that the CEO said to me, "Have you ever watched any hardcore porn?" And I said, "No." And so obviously I then had to look at this stuff. And if you haven't looked at it, you don't know what it is, I think. And I think that's quite important, otherwise you can't really actually talk about what it is. I think the porn in the online world is much more hardcore and extreme, not in a technical sense of extreme pornography, but it's much more specialist. There are about 80 different categories of various activities, which, you know, it is about fantasy. And I think that is an important point to make. We're not just talking here about explicit sex. It's more than that. It's actually abusing and using the human bodies for things which perhaps it wasn't designed to, because it is about fantasy. That's what porn is about. So I think it's an important point. So it's not a moral point, but it's an important point to keep in mind. The second point I want to make is I think it's important in this discussion of privacy in porn, and I think this is what this session is about, is to make a distinction between legal and legal and illegal material. Because clearly legal material people can view, it's legal to possess, so we're concerned about people's privacy who access these types of legal materials. With illegal pornography, I think it's slightly different, because clearly if someone commits a criminal offence, they have a different argument as to what sort of privacy they should have, right? I mean, if you're possessing child abuse images, perhaps your privacy rights aren't quite as strong. So it's, I think even in this context, in the context of privacy, it's important to make this distinction. Now, of course, this is slightly simplistic, because as Abhilash helpfully has outlined, from an English UK law perspective, some types of pornography is legal to possess, obscene material is legal to possess, but illegal to distribute. Other types of pornography, such as child sex abuse and extreme pornography, is illegal to possess
government has said legal, illegal. Now, one of the main concerns in this area is child protection, of course, and rightly so. And this concerns largely legal materials with a legal review, but obviously not children necessarily using. I mean, some people take the stance, of course, that it's not really harmful to children, but in the UK there is a presumption that hardcore pornography is potentially harmful to people under 18. So there was, also we have a Conservative government now, and MP Claire Perry campaigned heavily in 2011, 2012, that we should have some sort of filtering by default. I mean, parents can always download or install on each device, of course, filtering. That has been there, I think, since the 90s. So a report was produced in Parliament which talked about filtering technology, but was rather worrying that that report nowhere mentioned that filtering isn't 100% a solution. It didn't mention underblocking, overblocking, inaccuracy of filters. So that, I think, is problematic, that the political debate in the UK never discussed the limitation of filters. And I think, I'm not saying this is wrong with filters, but you have to realise that it's not a solution. So it was introduced more or less without statutory backing, so there's no statutory framework for this, although there are discussions whether the Communications Act, which will come in the future, will actually include it. So the 5 largest internet access providers apparently have agreed to introduce this system. And what does it involve? So basically, if you're a customer of any of the 5 ISPs, which apparently cover 95% of the market, at some point you will get a message from your internet access provider and you will have to make a choice. And the choice will come up as a pop-up windows with several categories: pornography, gambling, social networking, etc. And the box which says that you block this type of content will be pre-ticked. So obviously all you have to do is untick it if you want to keep your connection open. So it gives the user a choice to opt in or opt out in receiving certain types of content. It's a kind of network level filtering. So the beauty is that it works across all the devices. So children now have laptops, computers, etc. So it works for all devices in relation to that particular connection. It was supposed to be in place on the 1st of January last year, 2014. Actually, having said that, I have never received this message and my connection is still open. So it hasn't been implemented consistently by all the internet access providers. Talk, I think, had this system for quite a while. So it's not yet fully implemented. So users choose the categories and they have the choice. Sometimes in the media it has been reported that the default option is filtering. That is not correct. The default option is that the connection is open and you will then have to make the choice. And obviously people can leave their connection open. So, as I say, the over-underblocking has not been properly discussed in public. Obviously all filters overblock, in other words, they don't let content through that should be let through, and they underblock in the sense that they let content through which should be blocked. And there's a correlation between the two. So a filter that underblocks a lot will not overblock and vice versa. Previously, so before this system, only 43%, LSE in London has done a large study on children's issues on the internet. And one of the questions they've asked, in a large-scale survey, how many parents have actually used parental control filters, and only 43% of parents use them. Why that is a different question. Are parents not aware? I think a lot of parents are now aware. Do parents think it doesn't work, or is it annoying because the child is doing his or her homework, and then will ask every 5 minutes, Mummy, I can't access this, can you remove the... I don't know why. But anyway, so only 43% of parents. The consultation which the government undertook before the introduction of the active choice in 2013, only 35% of parents, not 35% of priests, but 35% of parents said actively supported the introduction. So it wasn't actually all that popular. Now, what are the privacy risks? I think there are 2 risks. One is, of course, that when people make the choice and decide to leave their connection open. That, of course, doesn't mean necessarily that they watch pornography. It might simply mean they haven't got any children in the household, and they think, oh, what's the point? when the filtering actually takes place. Clearly, in order for filtering to be effective, you have to decide which site should be blocked, so there'll be probably some form of deep packet inspection and DNS filtering. So, in theory at least, the internet access provider may know which sites are being accessed if you opt for filtering. Obviously, if you leave it open, then there's no filtering in the first place. I, at the moment, politically don't think it's likely that ISPs will pass that information on to law enforcement. But it's about legal pornography. People are allowed to view and access this stuff. So I don't think the privacy risk is minimal. I think, from a political point of view, what is perhaps of interest to governments is the question of child sex abuse access and the blocking of child sex abuse being used for investigation and prosecution. That is a risk, I think. So this is not in the context of active choice. This would be in the context of the work of the Internet Watch Foundation. And I think the presentation we have just heard, the actual tracking of people's specific interests in particular types of pornography are much greater privacy concern, although obviously that's open to discussion because you obviously don't identify a named individual, but you probably link that profile to some form of digital fingerprinting or cookie or whatever technology is used. So although it's not a named individual, there is still an identifier which links this data to a particular computer or connection. And that is the privacy impact. So the commercial privacy impact, I think, is much bigger than, say, the one of the internet access provider. Now, search engines, of course, are another gatekeeper which are of interest here. Google is on the board of the Internet Watch Foundation, again, a self-regulatory organization. I think in some ways it is problematic that in the UK largely this is looked at from a self-regulatory angle. So it's all about agreements between the ISPs and the governments, and that's what the Internet Watch Foundation is based on as well. Google uses the Internet Watch Foundation, which has basically a list of URLs which contain child sex abuse images, and those are blocked out by the internet access providers in the UK. At the moment, this system is not used for investigation and prosecution of criminal offences, because obviously it is a criminal offence to view child sex abuse images on the internet, but there is that potential. Google has now agreed as of July 2013 that it will also block search results for commonly used terms in relation to child sex abuse. And isn't it interesting that the Pornhub year in review actually says that for men, apparently the most commonly searched for type of porn is teens. Now obviously that doesn't necessarily mean children, it might just mean young women, could be 18. But it is interesting in ways, and also worrying that that is the case. Finally, my last slide, I think. So, as I say, the BT Clean Film in the Internet Watch Foundation does not inform law enforcement. Of course, in the US, we have a precedent for blocking of child sex abuse images, which are actually used for law enforcement as well. So, the National Center for Missing and Exploited Children uses specific images to create a hash value and then searches email traffic for these particular pictures. If they are found, they will pass that information on to law enforcement. So this is, in a way, a first precedent where actually blocking, in other words, prevention of the distribution, is then also used for law enforcement, investigation, and enforcing the law. It's very specific in the US because they're only looking at particular pictures rather than obviously all internet traffic doing deep packet inspection, but it's the first step in that direction. That's all I have time for, unfortunately. Thank you very much.
Thank you very much. And with no further ado, Lawrence wraps up and then we will go back.
I'm going to start from a very similar place that Julia started from, and that is the idea of sex. I mean, the room is packed. We're talking about porn. It's always been that way. It's always, whenever you say pornography, my PhD jury was, the presentation of it was packed. It's a freaking law PhD. It's not that interesting. But the minute we start talking about sex, we talk about something that obsesses the human mind. But, strangely, it also creates this idea, especially when we're talking about pornography, it's something that we just, it's sex, I can't, we hide. And even, I rented a very cheap hotel in Brussels, as I often do, and I woke up yesterday morning to look up to mirrors on the ceiling. And I was like, of course I'm talking about porn. There are mirrors on the ceiling. But I was, at the same time, I was like embarrassed because it's about sex. I think that that is natural. Even the most liberated person who watches porn and talks about it, it still has that idea of embarrassment. And that's where I bring you to the tale of three tubes. There are three things that have happened over the last year and a half that I thought were worth mentioning, sort of to wrap up this very knowledgeable and deep conversation. I'm going to be kind of surface. The first one is RedTube. There was a controversy we'll talk about in Germany. Next is what's already been mentioned, the Pornhub Urine Review. And we cannot leave them out, the NSA is probably here anyway. Hi, Mom. Okay, so if we can start with next. Okay. To give you background, RedTube is a huge provider of online sexual content. In Germany, last year, there was a controversy where a law firm sent out demand notices for up to, the numbers seem to vary, but it seems to be between 10 and 30,000 users of pornography. And these were, they alleged that there was that they had obtained or viewed the material illegally in violation of copyright law. And they sought a disclosure of the names of these people. And they went into court, and their request was very ambiguous, seemed to use few words that made it sound like they were downloading the material, which is illegal in Germany. Turns out they were streaming it. But they sent out these letters asking for 250 euros a pop. Imagine you're at that breakfast table. Oh, please pay 250,000, or 250 euros, or we'll sue you for infringing the copyright. As it turns out later, after much uproar, and another law firm got involved, is that the courts determined that streaming itself wasn't illegal, but the downloading is. But these are people who stream. And what this brings up, especially from a privacy point of view, is that they weren't actually looking to enforce copyright in a court of law, I would surmise. What they were trying to do is extort money out of people who used pornography very effectively. You know your best, from a lawyer's point of view, you know your best adversary is somebody who doesn't want to go into court. Somebody who's embarrassed to go into court. Somebody who doesn't want to admit, I looked at Susie on a tractor XXX. You know, that's your best defendant in that case. Next slide. Just the RedTube front line, the front page. And one of the things that you don't realize when you go to RedTube is that you would even have an issue with copyright. So you presume, maybe foolishly, that you're permitted to leak, if you're over 18, you're permitted to see it and that it's legal material. Unless we think that this is just a German problem. In the United States, next slide. In the United States, there were similar cases. They're a little bit more in the past. They come from 2010, 2011, but they were what I call the John Doe cases. They were filed in places like West Virginia. I think they were Ohio, West Virginia, and Utah. And what it would be is somebody who had the rights to material, would find out who was, and in this case it was downloading material, and go after them in courts that were specifically difficult for these people to get to. So you might, under the idea of diversity jurisdiction, you might have people out in Spokane, Washington, or, I don't know, Mumble, Georgia, having to go to West Virginia to defend themselves. And what, after a little bit of digging, the subpoenas were originally authorized under the Digital Millennium Copyright Act. And I mean, if you're a practitioner, you can go into a court and you say to the judge, I need a subpoena for disclosure of this material. My client owns the rights. It's very, very minimal generally before this. But what started to happen was courts would start to say, well, wait a second, how did this material, like how are you alleging it got to this person? How did they download it? And what it turned out was that most of these downloads were through BitTorrent. And a lot of times these weren't actually people who had ever downloaded it. There was a blind guy. I don't know, I just seem to think he might have a defense. Well, maybe. There was pensioners who didn't have computers. There was, you know, it was, the way it was is that, well, they would have to have access, but there was ways, the system of issuing subpoenas under 512 of the Digital Millennium Act became much more strict as a result. The courts seemed to solve the problem by saying, okay, this is an abuse. And one of the things that they looked at was the fact that the letters that went out, and I think that they were, I didn't put it on the slide, I think they were looking for $2,900 per pop. That's a huge amount. But if you're in a situation where you get that letter at the dinner table, or you're like, this isn't me, but I've got to go to West Virginia to defend, it might be cheaper to pay the $2,900. And what the courts found, and commentators have found, is that this was specifically lawyers trying to make money. You know what I mean? I take a third, you take 2/3, we'll see what we do. You know what? If we shoot in a barrel, we'll see how many fish die. Analogy, but okay. Okay, moving along. This is kind of a whirlwind on what's going on in tube law. The Pornhub year in review, if you haven't looked at it, it's worth it, you know, to click on the site. It's from Pornhub Insights, actually, so you don't get to look at the porn itself, you can just look at the statistics. It's a 2013 survey. I haven't seen the 2014 survey, and it should actually be out by now, but they haven't seemed to release it. I wonder if it's due to a backlash of the survey. But Pornhub looked at the user habits of their users, of their customers. They break down from time, date, location, devices, and search terms. They cross-reference with different events that were occurring so that during different rugby matches or different American football matches, they would see that, oh, during the playoffs, it went down, or if they lost, and this city went up. And I have to say, they have a very good sense of humor. One of the things that they tracked was when Scotland was taking the independence vote, they compared usage in Scotland versus in England. How many minutes are the Scottish on there before they're done? And how many minutes are they, I mean, it's got a sense of humor to it. Yes, and Pornhub, again, the statistics are very difficult to nail down, but the one conservative estimate was 1.6 million views worldwide per hour. That's a hell of a lot of people looking at porn. The problem that I have with this, or from a privacy point of view, what problem we might have from this, is how specific does it get to that point where you're identifiable? Okay? This is England, Scotland, and Wales. Right? So what they did was you could see the search terms that people are looking at. I don't know who Lisa Ann is, but she's very popular apparently. British, Scottish, smoking, and you know, you look, smoking? You know, and when you look at the different terms that, and I won't repeat some of them because I'm looking at it. But you see how it does. This is fine on a national level, maybe. It's kind of interesting. It's kind of sad in some ways. Okay, but what if you break it down, instead of being Edinburgh, Glasgow, Aberdeen, well, I don't know Scottish towns, what if it ends up being Tuchma in County Mayo, Ireland, or Bonnefoy in Luxembourg? As the towns get smaller, it gets easier and easier to identify the people who might be using porn. I mean, there's a study out of MIT, I think last year, 10 minutes, okay, that says you only need a certain, I think 4 or 5 points of reference to identify a person directly. That's a privacy issue that we haven't even started to look at. Next slide, please. Just to show you can go on the two, because I'm running out of time, you can look up by country. So here in Belgium, French, compilation, teen, anal, MILF, and casting. Okay, we couldn't look on Luxembourg. I tried. It's not, we're not a big enough market apparently. Okay, next slide. Christmas Day. Except in Japan. Okay.
No such thing as Christmas in Japan.
Exactly. So the next slide, real quick. Okay, I want to end on this, and I really feel like, you know, these are all, they could have each been a discussion in and of themselves, but I think there's 3 different points. NSA recently was revealed through the Snowden descriptions that they are tracking the porn usage of people that they think are extremist, Middle Eastern extremists, to use it to discredit them. And we had a discussion about this thing. That's remarkable because that's McCarthyism. But it's nothing new. In September, the New York Times released a letter from the FBI, an anonymous letter from the FBI to Martin Luther King, where they actually refer to him in the opening as King. They will not use his doctor, his preacher. They just said King. You are worthy of no respect. Apparently, the FBI had come up with, I don't know, either made it up or actually had it, a sex tape between Martin Luther King and somebody else. And they were trying to get him to commit suicide. And they used it. Because sex is so, it's still that taboo, 1963, 2015. So I guess it's something to think about. It's very sensitive material. Last slide. It's very sensitive material, but we have several different people looking to get their hands on the information to use it either for good or not, for humor or not. You have the industry trying to exploit the data to protect their rights. Or, as we heard today, we have the industry trying to say, I want to serve the user. If you like French maids, I want to give you French maids. Okay? You have the government trying to exploit it. NSA. Enforcement of laws, very legitimate, but some of it's not so legitimate. Rights holders, and that's where it gets difficult. You have the legitimate right holders' concerns, but you also have people that are using that because it's sex to try and get on that idea that people don't want that private information. Thank you.
Being moderator of such an interesting and diverse panel is challenging because I've got enough questions to fill up our lunch break, but I don't want to talk, I want to give you the chance. Please keep your questions short so we have at least a good 10 minutes also for them to respond. Who wants to give this start?
Okay. I would like to connect the last thoughts on internet surveillance to two things the first and two second speakers had done. Because I was really wondering whether anyone after Snowden and what we know about the GCHQ can now on to say that internet service providers are not going to distribute any online behavior to government agencies. So I was wondering how you can actually argue down that line. And the other one is about the advertisement and profiling industry. I'm a bit reluctant to buy your thoughts on anonymous tracking if we connect that to what we now heard on the interest of internet surveillance agencies. And I mean, for a start, I guess you track IP addresses, and whether or not people stay anonymous when you do that will decide the ECHR this year or next year maybe. So is it actually true to talk about anonymous data for a start there?
Many probably were covered that question you had.
So we are calling it anonymous because we are not using it. We are not interested into what people are doing specifically. Because the goal of advertisement is to build up a profile to a certain population that we will be able to advertise to. We have the right to store the IP address, but we are not using it because the IP address is versatile. You can change IP address, you can use a proxy, it's not usable. So I totally understand, and I am concerned as well about my privacy when I'm browsing on the web. But all the advertisement industry is using the data you are providing anonymously. I'm repeating anonymously because we are not able to link to this to a name. We are using this data just to serve advertising. protection about data is really strict in Europe, and we are advertising from Europe, and we have to be really careful about the data we are storing and how we are storing it. We have to get through a lot of certifications from security companies to be able to store that data and to use that data internally. So we are sticking to the law. The law is our guideline, and we have to stick it to it. If we want to go further about data protection, the law will teach us how to do it and what to do. Maybe there is a work to do with the governments to help them about a bit to understand the advertisement business, because sometimes we really understand that there is a huge gap between what we can do and what the government understands what they can do.
The response as to whether governments are interested in people's viewing habits of legal pornography. I mean, I was just thinking, I think other issues are more predominant. I think governments soon will be interested in who's accessing, say, so-called extremist sites, say with radical, fundamentalist, religious views. That sort of thing, I think, will be much more prominent than who's watching, you know, normal, legal pornography. Whether it is used, so I guess we have to ask the question, why do governments survey people? They survey people because they want to find a haystack in the needle, which rightly or wrongly, and they want to find out who is going to commit crimes, who is going to be a terrorist, who is a terrorist, and as part of that profiling, what is the role of pornography in that? So pornography can be used, as he was saying, in a way to blackmail people, to, I guess, in an interrogation of a terrorist suspect. I'm sure that would be interesting to use that. But it's not the primary goal of enforcement action. So I personally, I'm much more concerned about political websites and governments tracking who accesses those and what are they saying on those websites than, say, the tracking of legal pornography. I think it is an issue, there is a privacy issue, but I think it is of less urgency than some of the other content. But in relation to the private sector, and I'm saying this now as an academic, I hope you don't mind that, I think it's already problematic that those profiles exist. So even if you say we comply with data protection law, we're not going to leak this data, we're not going to leak it to an insurance company, etc. The danger is that one day, law enforcement will already at this stage have the power to tell you you have to disclose this data, whether you want it or not. So data protection doesn't give us the guarantee that law enforcement cannot go in there, because obviously, as we all know, there are exceptions, etc., where law enforcement will say, you have to tell me what. So I find the gathering of data by the private sector more problematic than what the ISPs are doing.
So if I may add really quickly, the people who challenged the 512 subpoenas in the US and the advocates for privacy in Germany were overwhelmingly the industry. They wanted to protect their clients. I'm not, I'm always a little suspicious, but having said that, I think on the other issue, I think that the pornography data that might be collected by the government could be a red flag. It's ancillary, as you say, but it could be something that say, okay, we're keeping that in the back pocket on you. You're on that list that I've got to watch out for. You were on the political things. Now I got two things. And I think that's where it becomes difficult, especially as the abilities of government and business becomes greater to collect more data and synthesize the data. I think that's where it
Next question.
I want to quickly follow up on that, because I think regarding those issues, it is important not to only look at what governments actually will be doing or are doing, but what just the impression that I'm being watched by my government does to me, especially, and that relates to Lawrence's first story, when it comes to pornography or sexual content, because then I don't want to be watched. And that's effects that are sometimes completely independent of what's actually happening with the data, but what's happening in my head and the perception of being watched.
I think that something which is really important, and what you say too, is the problem of interest. We say that it's problematic that private companies get data, but what interest is behind that? We don't have any interest in saying that Lawrence loves a French maid or whatever. We have an interest to give it what he already wants. So it's really different from state. From my point of view of an advertiser, it's far more dangerous that the state collects data than a private company, because private company has to have compliance with its client's goal. And his goal is not to destroy his client, it's not to blackmail it or whatever I can do with that. His goal is to serve his client as long as it's legal and authorized by law.
We take two more questions. The first one is already handed over, and that will be the second one. We first collect the questions, then the answers.
Sure. Well, I just wanted to go back to this intriguing slide you had, sort of comparing the NSA to this FBI harassment of King. I mean, first of all, I would be careful to conflate these two kinds of agencies. To my experience, they have very different organizational cultures. So that FBI has a real history of sort of going on their own ideological crusades and sort of delegitimizing somebody who they disagree with on any basis possible. NSA is not a law enforcement agency at all, so there's not a whole lot that they can do besides surveil. And in terms of personality, the average NSA cryptologist, in my experience, is really a lot like this kind of Alan Turing type. You know, they're sort of brilliant academics who take it a bit far sometimes. You know, but they're not, you know, screwing with people. They're scientists. But you know, the other interesting thing that your slide raises is there's long been a sort of ethical debate within the gay community about when it's okay to out someone. And it's a contentious debate, but they seem to have arrived at this code of conduct where they don't bother the teeming masses of closeted gay Republican staffers that are all over U.S. Congress. I mean, it's like Club Med over there, but they leave those guys alone. But when you've got a politician, a public figure, who is making a point of crusading against gays or in favor of sexual purity or censorship or something, it's the hypocrisy and the fact that he's a public figure that they then feel entitled to call out, you know, when it's found out that this person is soliciting, you know, male sexual attention in a Minneapolis, you know, airport bathroom. Not to say it's ever happened to them.
Judith?
Yeah. I've got two questions, we probably won't have time actually, but the first one is slightly heretic, and that is this whole idea of internet porn regulation. So to me sounds a little bit like a law of the horse, the most famous law of the horse. Because all of the issues that you've touched on, I've just done my little list: profiling, filtering, blocking, copyright rip-off schemes, online anonymity and identifiability. They are all much bigger things. And what I'm always worried about when we're making this about porn, is that we're engaging in these discussions on their terms, on the terms of the people who want to do the blocking, the banning, the, you know, preventing anonymity and stuff. And I'm on the advisory council of the Open Rights Group, and I have to admit I'm an 80s feminist, so you know I have no great love for online pornography anyway. But I'm always saying to my colleagues, let's not make this about porn, because this is actually about infrastructure. This is about what they could do in other cases. What Julia just said about, you know, infrastructures for filtering can then be used for other stuff. So I think we need to maybe take a step back and not just make this about porn, but make this about all the things that are currently happening that shape our internet behavior. The one thing that I would quite like to ask about porn, and this is specifically to Abhilash actually, is your argument about why this maybe shouldn't have been regulated the way it was that there was no harm evidential. And I think this is something that AIDS feminism coming in again doesn't sit well with me, because I do think that we need to think about this slightly differently, and what I would be interested is to find out actually what kind of evidence would you accept. And I'm thinking about two things specifically here, and I hate so much to pull the thing with the children card, but you know, one of them is actually creation of expectations of women and female sexuality. I think this is a really big thing for me, and I know that this happens in teenage girls and teenage boys, because like my girlfriend's a teacher and she confiscates those mobile phones. And she speaks to those kids, and this is something, you know, how would we prove that this is actually a kind of harm that is maybe happening in childhood or in teenage time, but goes on forever? And the other thing, which is quite a curious one, which is actually something I'm doing at the moment on real person fan fiction. So where fan fiction is written not about the characters, but about the actors that are playing the characters. And I've just done a lot of this in a sort of gay, you know, a gay fandom. And apart from the exposure to gay sexuality that I've never really had as a lesbian, the real idea here is, of course, we're talking about real people doing these things that maybe they're not actually doing. So privacy, not about the privacy of the person watching the porn, but maybe about the person actually becoming, invariably and maybe not very voluntarily an object of the porn, and that is quite interesting to me.
I know we're battling lunch, but since a lot of interesting points have been raised, I hope you agree with me that we give the panel a chance to answer. We start with you, Abhilash. Everyone that feels like giving a closing word can, using those comments. And if you mind not getting up, because I will create a lot of loudness now, 2 minutes and we're done. Abhilash.
Quickly, on the harm, evidence of harm. What would you accept as acceptable evidence of harm? The lack of evidence is actually acknowledged by the Home Office document itself, which was issued in the run-up to the legislative process, that there wasn't anything available which points to any evidence of harm. They're letting people watch it, but of course to lead to normal people turning into evil people, right? So I hope sort of that.
No, it's the indirect harm I'm interested in.
Yeah, but again, they were talking about that indirect harm. That we acknowledge that there is no credible evidence of direct or indirect harm in the proposed legislation, but nonetheless we're concerned with the risk of harm. So there's a distinction between credible evidence of harm and risk of harm. And the risk of harm has been used successfully when it comes to regulating adult pornography with respect to children, which I can argue in the sex shop. Not because, again, there was any credible evidence of actually harm, child being harmed, but also there was a perceived or a credible risk of harm at least, which is good enough because they were children. But here you're looking at consenting adults creating content, and consumers, again, adults who make an informed choice to watch it. And I appreciate it's a very difficult one, but I still stick to insufficient harm. And
so what evidence would you accept?
We discussed that at lunch. Go on with your second point.
Just about the children accessing pornography. Again, if I look from an experience, that's not just an issue confined to state pornography. Children have been prevented from accessing inappropriate content. That does not just stop at pornography, at other types of content as well. But again, I don't think that possession of things stopping people from accessing those images would replace that, because technically speaking, if you strictly implement the legislation, even a child looking at that will be committing it as that criminal legislation.
I think also the question of harm is who has to prove the harm. Should we have to prove that certain types of pornography are harmful before we sort of restrict children's access to it, or is it the other way around? Should we say, well, if in doubt, protect children? I tend to, I think, agree with the latter in relation to the child protection argument. And I personally, responding to your comment, although this is not strictly a legal comment, I don't fully understand the feminist argument for free porn. I still think porn, to a large extent, looking at the stuff, I'm not a researcher in this area, but just looking at the stuff, is about the objectification of women. To some extent, if there's a need for that, that can be justified, but the degrees of it, I think. And I think that is the issue.
Really briefly, with the NSA stuff, just plainly, the proof is in the pudding. If you're acting like the FBI, I'm going to judge you as though I would judge the FBI. I don't care if they're a bunch of geeks or scholars or philosophers. However, it's just the pattern that they're up to, and if they're using it, somebody had to give that authority to do it, and that's reprehensible. On the other issue, I think that's where we miss the role of the family. I have conversations with my teenager sons and my preteen daughters about sexuality, about objectification. I mean, we really go into this. That's my role. And I tend to think, and this is where Julie and I tend to butt up against, is that I think when it comes to freedom of expression, you have an obligation to tell the families, protect your kids. It seems from your slides, 43% of them, or I don't know, there was a very low percentage of wanted blocking. These are people with kids because they know. They say, oh, it doesn't, no, number one, it doesn't work, but number two, that's my job. If I don't want you on the computer, I'm going to kick you off the computer. I mean, that's the role of the family.
Okay, with that, this was the first time the University of Luxembourg and Münster joined for CPDP to do a panel. We think we took the right topic. There's lunch now, so you can discuss with them further, but join me in the round.